My name is Lucy Commoner. I am the head of conservation here at the Cooper-Hewit and also the organizing curator of the exhibition Multiple Choice from Sample to Product. On behalf of the museum, I would like to welcome you to the Cooper-Hewit National Design Museum and thank you for joining us for this event in conjunction with the exhibition, which is just outside these doors. I would also like to acknowledge the generous donors who made the exhibition possible: the Kobe Foundation, the Getty Foundation, and the Smithsonian Women's Committee. The exhibition, which is drawn from the collections of the Cooper-Hewit and the Smithsonian Institution libraries, explores sample books and other sampling formats from the 14th through the 20th centuries. These objects are tied together by their common function, that is, to record, market, and disseminate design ideas. As material records of design alternatives, samples contain a rich trove of information about technology, pattern, style, and color. Beginning in the first quarter of the 18th century, sample books were available early in the season, providing a preview of the newest trends. The advanced view made sample books a perfect target for plagiarists hoping to produce cheap copies. In this highly competitive textile market, a huge demand for novelty fueled piracy, which in turn provoked new technological developments and contributed to their diffusion. Industrial espionage in the textile industry was so widespread by the mid-18th century that pattern protection legislation was enacted in both France and England. Tonight's program will address contemporary proprietary design issues and examine the delicate balance between the protection of design rights and the innovation fostered by a competitive market. We're very pleased to have as our moderator tonight Eric Wilson, who has been a fashion reporter for the New York Times since 2005. Eric is a New York University graduate in journalism and fine arts, and he has written about fashion since 1997 when he joined the staff of Women's Wear Daily. At the Times, Eric wrote several articles on the initiatives of the Fashion Designers of America in relation to the proposed Design Piracy Prohibition Act. Eric's articles have portrayed the issues from the perspectives of the designers, intellectual property experts, mainstream apparel manufacturers, fast fashion retailers, and everyday consumers. Eric?
I guess I'll start with a quick story about my background. It was about a decade ago. I was working at Women's Wear Daily, and one of my editors gave me an assignment. It was the Monday after the Academy Awards, and he wanted me to call a man named Alan Schwartz to find out what dresses he was going to copy that year. And Alan Schwartz, to those of you who don't know, is a designer of a line called ABS. And ABS specializes in making knockoff dresses. And I was amazed to find that not only did he take my call, but he rushed to the phone and was rattling off the stars and what they were wearing and which dresses he already had in production for stores like Bloomingdale's, Macy's, Federated, anywhere that would sell the line, and as quickly as he could get them into the store. There was no shame to this question, to what he was doing whatsoever. But he was producing Ralph Lauren's gown from that Gwyneth Paltrow wore, for example, and Jennifer Lopez's Bagley Mishka dress. And his samples, when I saw them, looked almost identical to the ones that the designers had made. Obviously, the fabrics were cheaper, but you got the idea very quickly. Today, the issue is very, very much different, and in only 10 years, we've seen a lot of changes in the industry and how clothes are produced, how information is disseminated, and who's looking at fashion. Because of the internet, sites like Style.com and Women's Wear Daily's website, people are able to see the images from the shows within a matter of hours after they happen. People in Ohio can see a show from Paris. People in India can see a show from New York. And because of the computer-assisted design programs that are out there, they're often able to using the pictures from those collections, actually reproduce them in a very similar manner. And because of that, they can then have them in the stores often faster than the designers can produce the originals for the high-end department stores. So this has raised a number of issues, not the least of which is the impact of piracy on designers and the fashion industry as a whole. It's not a new issue, as I'm sure many of you are aware. It's dated back over a century. In the 30s, there was a trade group called the Fashion Organizers Guild of America who sought to outlaw copies by working directly with the designers in the department stores. They asked the designers to register their designs, and then they worked with department stores and asked them only to buy those designs that have been certified. They also asked the designers not to sell to stores that did not agree to this, and that, it turned out, violated antitrust laws. So in 1941, the Supreme Court ruled that they could no longer do this. Then in the 50s and 60s, we began to see the legitimized copies coming from Paris, where American manufacturers that were beginning to produce clothing wholesale after the war were paying a fee to the French couture houses to buy their patterns. They'd bring them back and reproduce them, have elaborate fashion shows in New York at Orbach's, and people would place their orders for couture copies. And it was widely accepted and considered quite fashionable. As American designers began to become more and more well-known, this practice sort of fell by the wayside. We began exploring the idea of what is original design and what is American design. And today we're at a point where the issue has come up again, and the Council of Fashion Designers of America 2 years ago began lobbying Congress to introduce a bill that would outlaw direct piracy. We've heard a lot of support for this in Congress, both on the House and Senate sides. We've also heard a lot of disagreements from manufacturers of mainstream apparel who are worried that the law could open them to liability and numerous lawsuits that may or may not have merit. So today, this is being debated between designers, some of whom feel it's not necessary and some of whom feel it's very important. So to discuss this matter, we're going to introduce the panelists. I just need to get the slides here. Our first panelist is Susan Posen. Susan is a Sarah Lawrence graduate and the Chief Executive Officer and Vice Chair of the fashion design house Zac Posen, in addition to being the designer's mother. She's also the mother of Alexandra Posen, the creative director of Zac Posen. The company was started in 2001, and prior to that, Susan was for over 22 years, including 14 of them as a partner, at the law firm of Struck & Struck and Lavin LLP in New York City, where she specialized in securities and other corporate transactions, with a particular emphasis on venture capital investment in media and communications companies. She also co-founded Diva Capital, a venture capital firm focused on women-owned businesses. Susan is on the board of Teachers Count and has consulted to the New York Times Company Foundation's 9/11 Fund with respect to the Lower Manhattan Small Business and Workforce Retention Project. She's lived for 30 years in Soho with her husband, the artist Stephen Posen, who's also with us tonight. Harley Lewin is our second panelist. He's a lawyer with Greenberg Traurig with more than 35 years of experience in trademarks, copyrights, and lots of experience with the enforcement of intellectual property rights. He's very well known in the fashion industry for his aggressive pursuit of counterfeiters of luxury goods, representing a range of companies from Reebok to New Balance, to Hermes, to Cartier, to Diane von Furstenberg, who's the president of the Council of Fashion Designers of America, in addition to, and I'm just rattling these off, Jimmy Choo, BCBG, Merrill, Chai, which is a maker of salon-used hair straighteners, I'm told, North Face, VF Group, and Polo Ralph Lauren. For his relentless efforts, the New Yorker magazine summed up Harley quite neatly last year in an article that carried the headline, "The Bagman." I invite you to join me. I'd like to begin by showing a few slides of some of the pieces we've seen that constitute knockoffs in the fashion industry. On the left is a dress from Donatella Versace. On the right is a copy from BB. This dress was also copied by several stores like Forever 21. They offered it for between $50 to $100, and it sold out in those kind of stores. It didn't do so great for Versace, but it was a look that obviously had a lot of impact. This is Anna Sui on the left, and on the right you see a top that was sold at Forever 21. And this is a good example of how closely they're able to match the prints. And actually the top at Forever 21 was in stores at the same time that Anna's dress and skirt was in stores. On the left is a bag by Foley and Carina, which is a small company based on the Lower East Side. And they produce quite a charming contemporary collection of dresses and accessories. And they happen to be one of the most copied labels out there, partly because it's a small, sort of unknown designer, so people might think they can get away with it a little more easily. The one on the right happens to be by Stephen Barry, and this was part of Sarah Jessica Parker's collection called Bitten. This is the only case I've seen where once we published the photographs and pointed out the similarities, the store selling the copy immediately pulled it out of their line and apologized and claimed that it was a case of a prototype ending up in the collection by accident. So one story I recall about Zac Posen specifically happened just after his spring 2004 collection, which was called Sargasso. And I went to see Zac, and he pulled out the photography book of seashells and explained to me how he'd been inspired by the smooth interior surfaces and the fabrics and the colors that he selected and the way it was worn on the body, so that when a woman walked in it, it sort of flowed behind her, and it created a very impressive and distinctive silhouette that sort of became a signature of his for a couple of seasons. At the same time, we began seeing that dress pop up in other stores and under other labels. They were clearly copied from that. It was a hit for both designers. But Susan, tell me a little bit about the investment that your company and Zac make in design and why you think fashion designers need to be protected.
Well, I can't quite understand why fashion design is the only art form, if you will, that isn't protected. It seems to me a gaping hole. The process of designing a piece of work and the complexity of the idea and making samples and fitting muslins and hiring fit models, and the whole process of designing is fairly complex, and as a commercial matter relatively expensive in terms of the fabrics that are used. And this is high-end designer collection fabrics and construction techniques. And, I think, the law in terms of trying to protect innovation and to encourage it in this country gets subverted with the kind of copying that goes on. The designer, in a sense, invests his creativity, ingenuity. And that's not to say that a designer, or any artist for that matter, kind of gets an idea out of the ether that has never been thought of before. Everybody is looking to the past, to what's around them. They're received dishes for culture. That's what creativity is about, I think. And so they are looking at things, but you want them to innovate. These are the people who are going to make things differently, make you look at things differently. And what happens when you do that, and it takes you 5 months to produce the work, to get it into the stores. And, if in the beginning, the dress you're talking about, I think we probably made 30 of them. I mean, that was, a big deal for us. Mr. Schwartz, who took the same dress, sold it to the same retailer unknowingly. I don't think the retailer knew what they were buying, but on one floor, designer was our dress, and on a, younger, less expensive floor was this other dress. Probably sold thousands of them. And, to my mind, I didn't get very upset at the time. Zac was kind of upset, and I said, you have plenty more ideas, don't worry about it. And it was also a question of, does a young designer who doesn't have, unlimited resources have the ability to do anything about it anyhow? I mean, we have lots to do, and you can't kind of get yourself tied up with this stuff and spend your time on it. But there's a point when really I see it as your own intellectual property that you have the right to commercialize, and it, for some limited time, which is what the proposed law provides, you have the right to, in a sense, rip yourself off, diffuse yourself. And in a sense, it's a way of amortizing on a commercial level what you've invested into it. It seems fair and reasonable, and it shouldn't stop trends from developing or people from being influenced by what you do.
Well, there's a lot of issues that are intertwined in this subject, and it's confusing to a lot of people just to understand the difference between counterfeits and knockoffs. What I showed you examples of are knockoffs because they don't use the same labels. Harley, this is your subject, your expertise. Would you explain, as you can, what is a counterfeit, what is a knockoff, and why one is protected and one is not? And I can pull up your slide here.
That's a bit of a loaded question.
It certainly is, but answer it however you see fit.
Yeah, yeah, there you go. There are differences between trademarks and copyrights. There are also differences between what is or is not a knockoff or counterfeit. Let me address yours first. The counterfeit, the pure counterfeit, starts with the concept of using something that is a registered right. Using trademarks is an easy example. You have traditionally back in the 1700s in England, it started with silversmiths, and they used to stamp every piece they made with what they used to call the maker's mark. That maker's mark became a symbol of origin, a source. It indicated where something came from when you saw that mark. A trademark does that today. That's why a trademark is an adjective, not a noun, although people change the words to suit their fashion and will genericize words as they go. But trademarks are essentially modifiers. Use Reebok shoes, use Diane von Furstenberg dresses, or DVF dresses. And the law provided, or does provide now, since 1984, a statutory scheme that says that a copyright, a counterfeit, is a garment or a product to be broader, that uses on it the registered mark or the registered copyright for which that has been registered. That is to say, Reebok has been registered for shoes, New Balance has been registered for shoes, Cartier has been registered for watches. And if you put Cartier on the registered product, that's going to be considered a counterfeit without authority. If you put the same word on, say, umbrellas or swim fins, it probably wouldn't be considered a counterfeit under the statutory scheme, but might be considered a knockoff. The way people use knockoff, which is really a non-legal phrase, is where you take the essence of something, or its essential pattern, or its essential style, and try, if you're a knockoff artist, to copy it without crossing over the line in the sand that says, no, you've gone too far, and you've now entered into what is the illegal knockoff part of the activity. So there's a pretty strong tradition, especially with apparel, as you were talking about in your introduction, of knocking off designs. And that is the debate. To some extent, the debate is, where do you draw the line in the sand? Mm-hmm. What is permissible versus impermissible activity? But counterfeiting is a statutory term, and it really means either the 100% copy or one that's awfully close. Mm-hmm. You know, we have one that we're looking at now, which is DBF. And we had the New Balance where a guy brought in 8,000 shoes, and he had on the side the word zebra, and of course he had the N on the side of the shoe, but he claimed that was a Z that was tilted. There's a lot of creativity, but essentially there's some point at which either the law or practice and standard says you've gone too far, and that's when you've crossed over.
Mm-hmm. And the counterfeit trade, like what we see on Canal Street, is illegal, as I understand it. But yet it flourished for quite some time. And it's only recently we're starting to see raids in those areas that have had any kind of dent on that. Can you tell me why it's taken the amount of time it has to see more enforcement of that issue?
Well, I think that there's a balancing that goes on. There's in the case of street activity, when you're talking about Canal Street, when people talk about Canal Street, there's really two Canal Streets. One is the stuff that you see on the street, the little retailers, the little vendors that are selling goods. There's a whole other thing that goes on underneath the street where that part of New York is being used as a wholesale operation and brings product in, monkeys with the product to make it look like it's real, and reships that product, and we found it all over the world coming out of New York. And that's a whole other business that goes on. Many of us do not necessarily believe in chasing retail, or what we call chasing product. But I used to do this as a lark. There's a very famous area in Beijing called the Silk Market or Silk Road, and clients would periodically see their product there and be absolutely appalled at the tens of, and they would insist that we go ahead and do it. And I said, you're making a mistake, because it isn't going to mean anything. And I say, okay, and then we would go through an action, we would dry up, and then we would walk across the street, and within an hour guys were coming and refilling everything. There's a lot of that in Canal Street. There's a lot of what you see is nasty, and it represents a thorn in the side of the brand. But when you're looking at a brand, you measure a limited amount of dollars that any brand has to spend to protect itself against what is the best way to spend that dollar to maximize the effectiveness of what you're trying to do. And when we go through the analysis, we generally follow a very simple premise. You cut off the head and the body dies. And we view most of the retail operation in Canal Street as fingertips. The reason that Canal Street more recently has undergone some activity, and there are multiple ways it has. I was down there for some of our handbag clients before Christmas because it was before Christmas and everybody stocks up. And the brand had made a decision on a management level that it just couldn't tolerate that anymore. More recent activity was done actually using the law that actually we had developed back in the 1980s from a case called 1165 Broadway, where we found an old law that used to be called the Bawdy House Law, where it evolved, but in simple terms, the law enforcement group could go and declare a place rather than a person as a place used for prostitution or drinking or illegal activity, and could close it and seize it. And we adopted that law to a building at 1165 Broadway in about 1987, effectively. And that's what the mayor just reused because he came under enormous pressure to do something about this. And there's a real interest that the authorities have because of the tax money that they're losing. So it's a huge amount of money that gets lost in the illegal activities.
And then when the clothes that we see at Forever 21, now this is a different issue,
Yes.
and we've seen a number of cases come up recently where designers have started suing Forever 21 because they say that they're selling clothes that are copies. What's protected right now? What's not?
Well, if we're talking about garments, in particular, and that's what we're all here about today, at some level, textiles and garments. Very little is the answer in the United States. Susan had raised an interesting question, right, when she rhetorically, which was, why isn't it protected? The actual historical antecedent of the answer to that question is because textiles have been considered a craft, not an art. And when we deal with Congress or the judiciary or other people, there's still a lot of that residue that is not seen, the cut of a fabric or is not seen as art. The part that is seen as art is the print or even some colorway or patterns of color. That it would be, I noticed in the display outside, there's textiles, pieces of textiles in frames. Every one of those could be separately copywritten as a photograph or a painting because people have no problem understanding that part of the art, the creative pattern that turns into that framed item. We protect that when the patterns are adopted to fabric. That's about it.
But it's puzzling because even, I guess Justice Douglas in the case about fabrics and the notice on the selvage edge of a fabric dealt with that in terms of the commercial interests at play. And I think what gets confusing here is when you talk about it's not art. I mean, the fact is and I think for myself, it's really important to separate the two things out. There's one thing about creativity and the art of being a designer or a musician or any of these other kinds of art. But what we're really talking about is something here where there's art and commerce. And the idea of copyright law, as I understand it from Justice Douglas and then a line of cases, is that what's really being protected and encouraged here is the ability of the designer, the innovator, to commercially realize the benefits of his efforts or her efforts for a certain period of time. So the new act is asking for an 18-month sort of safe harbor, if you will, in which the designer can knock himself off. And it, it seems kind of minor, but at the same time, there are questions of how you want to present yourself to the world. Do you want to take advantage of that ability to, go do something at Target yourself rather than have somebody do it instead of you where it looks like you? You have the right, in a sense, to build your brand in the way you see fit. At least that's how I see it.
Can I respond to a little bit of that?
Go ahead.
I think Susan's got it half right. I think that there is unquestionably a need to encourage design. And I'm usually on the plaintiff side. So if I walk in the courtroom, I'll agree with you 100%. But for the purposes of this discussion, there's an old, well, you do want me if I'm on your side of it, but there's an angst which exists in the United States, which really doesn't exist in many other countries, between the encouragement of individual design or individual creativity by the granting of what in effect is a monopoly, whether it's a patent or a trademark or a copyright or a design patent, versus encouraging the exploitation and further creativity by permitting the public at large to take that design, improve it, change it, work with it, and so forth. So there is a constant dialogue that goes on, and the court law, which has evolved in the United States in terms of copyright, has in particular grappled with not pure art. Pure art's easy. A photograph or a painting and the non-reproduction of that is easy. As Susan said, it gets more difficult when the art is integrated with function. And there are several classic cases. And probably the most classic case is a case where a table lamp had integrated as its body the sculpture of an individual, and then sought to prevent the reproduction of that by someone else. And they were granted a copyright in that because of the artistic part was considered severable from the functional part. And then other courts have said, more modern courts would probably not have done that because they now have some sort of amorphous statement where the artistic part has to be the primary feature of the utility item, where the item is utility. What is even more difficult is there's a very recent case, and probably the best known, most recent case in the area, has to do with a case called Samora Brothers in Kmart, which was an attempt by a designer to protect the pattern on a bedspread, claiming trade dress, not copyright, but trade dress. And the Samora Brothers case said, yes, it's art, but it isn't unique enough, essentially, that it was a repeated pattern that was not, and they found it not protectable. They found it, they drew another line. So, and this isn't over. It happens to be a client of mine that's leading the charge on the bill that's before Congress. And I entirely endorse the bill. I think it's a very well-written bill. I think it will probably get tweaked at the end, but I don't think it's because of the idea that a designer wants to bastardize his or her own work in some other fashion. I think what it really is again the effort at the end of it all to give some reward to the designer for the creative aspects of what they do before the design itself suffers copies of some sort. It not to let the designer copy himself. That may be a net result, but I don't think that's what it's because I can tell you that with respect to the designers that we act for, even if they did work for Target, they would never duplicate their high-end line. They would do something else. And it, in and of itself, would suffer that same safe harbor. I don't really think that's the purpose. I think the purpose is to extend the protection beyond the patterns to the garment itself.
That doesn't make any sense because a designer designs a line, orders are placed, it's a one-time kind of thing. First of all, you order enough fabric for that cut ticket, so to speak. It's not like you can wait and see, how popular it is, and for 18 months continue selling it. Once it's out one season, it's old. So the protection is sort of, it's like a Pyrrhic victory in a way. It doesn't do anything for you.
Well, that's really not accurate. Again, the experience of Forever 21 and what you were talking about with me earlier is, and this is really one of the issues that we're all grappling with. If you go back in history and the concept of the craft and now the art, and then the concept of the art and why protect it. There's a very strong argument that's made by many people that the industry has lived to the point of being a $161 billion industry in the United States alone. With all of this copying going on, why not let it live that way? It's doing just fine. Everybody's making out. Why extend this at all? And what is the significant difference between 5 years ago and today? And the big difference is the speed and the extent of what happens. We have direct experience where our clients will do a runway show, and they're showing, for example, there was just a fashion week in New York where they were showing goods for next fall. So their process is they take orders, they cut the goods, they make the goods, they start delivering end of June, July into August for fall. We have goods on eBay now, and these are not knockoffs, these are fakes, but to show you the speed of next fall's fashions in a matter of weeks from the runway show. That's what the bill is designed to deal with. It's not designed to give somebody 18 months, because even if you did a deal with Target, at least most of our designers are the ones who do the current deals, and we have designers that do both, have their own line and then design. They make a distinction. They'll draw a fairly bright line in their creative endeavors between what they do, but it is really the speed and volume. Right? And I give you a very pertinent example, both with respect to knockoffs and counterfeits. We represent Diane von Furstenberg. When we started representing Diane a number of years ago, as she expanded and really took off, we canvassed the 6 major worldwide auction sites. And one of them, for example, is eBay. eBay has multi-language sites. So it isn't just eBay as we know it. It's eBay in Germany and France and Italy and China, whatever. And then there's one called Taobao, there's Overstock, there's iOffer, there's E21, there's a host of them. We found thousands of auctions daily of her products. Literally in the thousands. Now we've taken that down to about 200 or 300, which is a manageable number because many of them are true, authentic products, which are simply being resold for a variety of reasons. But it's that fast. And when you sell a mid-priced item, like a DVF type product, rather than an $8,000 or $10,000 handbag, the same buyer will buy the knockoff. Right? Virtually the same buyer will buy that knockoff as will buy the real thing. It's a dollar for dollar loss and you suffer the loss of panache, you suffer the loss of reputation, you suffer the loss of quality and brand. But the real effort is to protect that, to give them that window for just their own goods to get in the store. Because remember, your copyright attaches when you're filing and creating, because you have to register in this new plan. It's going to take 6 months before the goods go in store. So all you're talking about is 2 selling seasons.
Mm-hmm. Let me read an example to you because I want to hear how this impacts. You were just mentioning a mid-priced item. I want to hear how this impacts on a high-priced item such as Zach's, and also for a company that's beginning to introduce new products at lower price points. You have plans to introduce a denim collection next year, I believe. Or in the near future, in the vague future, we'll say. Narciso Rodriguez was testifying before Congress on this issue, and he said that the wedding dress he made for Carolyn Kennedy in 1996 became the most copied silhouette of the past decade. The quote he said was, "The pirate sold around 7 million or 8 million copies. I sold 40. But is there any way that actually impacted the sales of his business? Is it likely that 7 or 8 million people could buy the designer dress? And does that discourage people from buying a dress that they've, I mean, wouldn't an affluent customer be less likely to buy a dress that they'd seen it in the media already because they can afford an original looking design?
Well, I think this goes to kind of what we're all talking about, because I think a part of, the ability these days of a designer to, in a sense, knock himself off is a right that is inherent in this bill. I mean, we may disagree on it. I mean, I don't disagree with what you're saying about protecting the current market, but the fact is also that there are opportunities that exist for designers. And, we took a dress just recently that had been on Katherine Hagel in the Emmys. We had made one of the dress. It was a sample. It was a sample that she wore, and it was a dress that was never ordered by anybody, any of our buyers. And we thought it was a terrific dress. It got tremendous publicity, and we recently did something, a lower price collection, where that design was produced, 70 of them. Not a huge number, granted, but for us, that's a very large number. And had somebody else done it, we wouldn't have had the interest, or in a sense, the ability would have been taken from us to do it. It's ours. It was our creation. We should have the right to, in a sense, exploit it as we will. And then I think, again, it seems like it's a protectable right, and it's certainly, Narciso is very concerned, depressed, if you will, about how he's fared in with this dress, with other things. We all are. You start designing handbags, and you find that something that you have invested tremendous amounts of research and development into gets ripped off, and it's discouraging, frankly. So there's also sort of a global issue involved here, which is it's kind of turning into a flat world, and there's people and ideas moving very quickly across borders, and there's no longer the kind of time difference or even psychic difference between different countries of origin and where creativity is happening. In Europe, at least, designers are protected in this way. There is, droit moral and moral right that attaches to a creator's work, and I think there's also legislation as well. So, European designers who sell into the States are really questioning whether they're going to get exploited in a way here that is unfair, from their point of view, certainly. And so we're not playing on a level playing field in the United States, and I think it's, short-sighted, really.
I think Susan makes a number of points, which I agree with.
Thank you.
I think, well, I haven't really disagreed with anything. I guess I'm the lawyer, and I'm charged with taking, Zac's stuff and then going into the courtroom with, with my lance under my arm and saying, look, this is why we ought to do this kind of thing. But I've also been involved in the formulation and passage of legislation back in 1984 when we had no Counterfeiting Act. We got involved and wound up with a thing called the 1984 Trademark Counterfeiting Act, and it you pass a law and then it morphs as it goes on, and you realize it needs strengthening in some areas and weakening. But I think that a number of points that Susan's made are worth highlighting. The first is that. And she clarified, I don't think it's so much that designers knocking themselves off, but I do think a designer has the right to take a product that they have created and implement that product as they may see fit. If they decide they're going to reduce its price point by changing its material or altering the manner of production, they ought to have that right within some period of time. Again, if you go back to this constant balance between the angst of creativity on both sides, where there's a reason that there's a finite life put on the copyright that they're talking about, because people should have the right at some point to say, boy, I can make that a better way, and that's the part that everybody benefits from, and so you do balance that out. So I agree with that, and I also agree that the world is really small. I mean, I face that on a daily basis, and in terms of the origin of fakes and knockoffs and copies of all kinds. Handbags come from every place imaginable these days, and fabric is all you got to be able to do is copy the textile, and if you're in particular, if it's a print and it doesn't require the skill of weaving, it's even easier because you can digitize it right off the net, and boom, you can make, you send it out to a guy on eBay, on the internet. The factory can receive it, download it into a computer, and have a sample for you 24 hours later. So there is this. It's almost like wildfire and again, the designer doesn't really know. It has a line of product and doesn't know it's going to be a hit until it starts writing orders. And there's this lag between, because you can't start production until you really know what people want to have made. And if the other guys can produce it faster. But there's a part here that you didn't touch upon, which I would add, which is a bill like this makes it easier for the smaller company to protect itself because it becomes a per se issue rather than having to constantly prove originality, that you're deserving of the right, which makes it financially extremely difficult for the smaller company to protect itself. So when you create a statutory scheme, hopefully it's reasonably well written. There's certain assumptions that get made, or you come in with a presumption of originality. If you've created it and you can prove it, you don't have to go further, and there isn't a whole lot of defense to it. So it gives the smaller designer a bit more protection than they have, and currently they have virtually none.
I want to clarify something in sort of my attitude about this, which is that I really like the idea of the democratization of fashion, and I think that we want to be influential. We want to be setting how people look and how they want to dress. It's a question of direct copying that's objectionable to me. So what I'm hoping the bill will do is create what I would call in the law an interorum effect, and make people who make this their business have to think twice, make them have to change the design enough so that it's not confusingly similar, or whatever the standard that the courts will apply to this. But courts have been dealing with these kind of issues for years in other cases. What is pornography? I mean, all kinds of things where there's a lot of subjectivity involved. And, they've done it pretty well, more or less. And I think, if somebody knows a Forever 21 that you can't build a business out of, directly copying things, it would be a benefit to everybody. I mean, it would, seems to me, foster better creativity than the people who feel that they can just ride on the backs of the originator.
I think you're right. I think there's another little wrinkle here. I mean, there's a reason it's 18 months. If you get an 18-month window, by the time the copy can copy you legitimately, it's probably moved out of fashion.
Mm-hmm.
True. And let's talk about this issue of originality a little bit, because the common response is that nothing in fashion is truly original. And that's obviously the response of the people who are copying designs. But it's really interesting that this is happening at a point when the subject of copying in other fields has really been in the spotlight. You have the case of Barack Obama's, one of his speeches where he was lifting a remark from a colleague. You have cases of a children's cookbook that by Jessica Seinfeld that another woman claimed was copied from her book. So, and there's been an enormous amount of public scrutiny on these issues. The fashion issue has, gotten a lot of attention, but there seems to be a lot more justification for copying in fashion. Why is it something about fashion that? Explain a little bit.
Perception of craft. If you take music, there are 8 notes: do, re, mi, fa, sol, la, ti, do, and then there are flats and sharps. That's it in our tone scale. And yet, every day, people have managed to put all those notes together in new and creative ways. Designers do that too. But when you're talking about the perception of the public and the perception of law, it for whatever reason historically, and I can actually go back and cite you this because I did a little reading this morning before I came over. It's the only reason I know about this stuff. But the perception was that the person who sat down and, for example, wove fabric to make into it was a craftsperson, not considered an artist. Now that's changed, but the law hasn't caught up. In other jurisdictions, in Spain, in France, for example, which has the broadest coverage, they recognized, back in the 1800s and more recently by an absolute right, which extends to everything. The design of, a water heater, the design of a bicycle rack. If you design it, it's yours, period. The United States would dramatically disagree with that. There's a bicycle rack case where it's a kind of a nifty-looking bicycle rack, but it's a bicycle rack. And the courts in that case said, no, bicycle rack first, design second, you lose. So there is this perception, a historical perception, which has been part of the effort on the design associates, people engaged in design, to change, to be fundamentally accepted as artists, not somebody who simply is taking something old and throwing it on a woman and marching her down the runway, but that there's this enormous creative process, and that should be recognized as art, not merely sitting down and weaving a tapestry or something.
Fashion designers are the rock stars of this generation. Looking at the interest in shows like Project Runway, Ugly Betty, The Devil Wears Prada. Zac was a guest judge a couple of times on Project Runway. He's a bit of a superstar in that regard. Is there a generational shift in the way people see fashion and their feeling toward designers?
Well, with some historical perspective on my part, artists were rock stars of the 80s, chefs were kind of rock stars of the 90s, so this, kind of decade seems to be, designers. I must say that when Zac, announced he wanted to be a designer at a young age, it didn't have the glitz around it at all that it seems to have now. But that seems antithetical with the way, the view of apparel as a utilitarian object, and not worthy of better protection, is coming about. I think there will be a shift, but, it puzzles me as to why, the issue of creativity, when you read fashion design critiques or the reviewers, either, in Women's Wear, the New York Times, there's always references that somebody's work looked like or referred to other designers at different times. And it's not ever that they're copied. That's not what's being discussed there. And it's really not about this kind of idea of knocking off or direct copying. But it's a vocabulary that gets used because it's how you communicate to people what the silhouette is or what the design is. And so I think, everybody, and you said, what about creativity and originality? And it's something I said earlier. I think every artist of any stripe calls on all kinds of things and looks to the past. And in my view, anybody who doesn't know the past is unlikely to be able to create. And you have to, have that reservoir of knowledge, what's happened before, why it's happened, and want to push the boundaries. That is what it's about. A little less so in the United States historically than in Europe, but increasingly it's one world, and we're hanging next to the best European designers and the retailers, and certainly want to be taken with the same seriousness.
You also have in the fashion industry this unusual world where a lot of designers are looking at the same exhibitions, the same artists, the same magazines for inspiration. And one trend, for example, from the spring collections of black and white stripes ended up all over the place. What if everyone tried to register those black and white stripes on a dress? How do you deal with a situation like that? Does it not open up that kind of Pandora's box?
I think I can answer that. I think that if you were seeking to register black and white stripes, like a painting of black and white stripes, you wouldn't get any rights, period, because that is not in and of itself what would be considered the art. Under the new bill, in particular, it is the entire assemblage that would be considered the art. When I was talking earlier about craft versus art, the historical antecedent of that is that the craft part was the guy, cut the fabric and sewed it, and very little thought was given to how it came about, draping and where it comes from, or how it lays on a woman or a man when they wear it. And we've never questioned that certain patterns of color may be originally put together, even though a particular look may be somewhere else, but the selection of color and the selection of the pattern, that would be protectable, assuming it's original or it has some qualifying originality. What this bill is doing is different than that. This bill is going beyond that. This bill is saying that it is the garment, and that's where it's brand new. That's a very different thing. So it isn't going out and saying everybody can do black and white stripes. They could do black and white stripes till the cows come home. But it's how does it look? What is that overall impact of the garment? How's it been cut? Maybe it's been put together with 2 or 3 other things, and it's that entire assemblage that then becomes the subject of the debate of protection and originality, not the particular fabric.
And what about then trends in the bigger picture? This has been a big concern or a counter argument against the bill, that it would slow the dissemination of trends and slow the speed to market of mainstream manufacturers with their clothes. Why do you disagree?
I can't see why it would slow anything down, because all it really requires is that, even if somebody's looking, the next morning on style.com at one of our runway shows in Bryant Park and sees an image of something that they want to, emulate or copy, they get the gestalt of it, they get the idea of it, they just have to take it further along away from it. It's not hard. It's not going to slow a damn thing down.
I think that if you look realistically at business today, the vast majority of people in the industry manage to do it safely and comfortably and stay away from each other.
Exactly.
We're talking about a very particular activity which has, as a percentage of the business, is relatively small, but has enormous impact. Mm-hmm. When you're talking about the Forever 21s of the world. Because, and I want to go back to something you had asked, Susan, which is on the high end of garments. Mm-hmm. Since that's the oldest story in the world. You don't have the same consumer who's buying a $20 Rolex on the street. Is going to be the consumer that buys the $20,000 Rolex. But part of the reason the $20,000, and Timex will probably keep better time than a Rolex, because it's got an electronic movement as opposed to a mechanical movement. But the Rolex is a piece of jewelry. Just like Zac's dress would be a unique design, a unique creation, one that is, in fact, because of its high price and haute couture, is limited, and you lose the panache, which is part of the sale. It isn't merely the garment itself. It's everything that is the fact that it's in limited supply is one of the reasons it sells. And when it becomes available in a wide supply to a different consumer, then his garment loses sales, because it loses the ability to carry all of those special things with it. That's where that comes from. And we hadn't really made that point dead on, and I think it should be made.
I agree. Part of the designer's job is to create demand for their fashion, for trends, for everything else. And part of Forever 21's job is to bring the supply to the masses as they see it. And because of the way young people have gotten into fashion, a lot of people now see Forever 21 as fashion's version of a Robin Hood, stealing from the rich designers who can charge an arm and a leg for what they're making and giving accessible fashion to the poor. One manufacturer I profiled last year told me that everyone has a right to look fabulous. And Lynn Yeager, in her Village Voice column this month, said, "I am an unequivocal fan of replicas, knockoffs, copies, fakes, and phonies of all stripes. I rejoice when I see Marnie-esque make-believe at Old Navy, Art Nouveau proto-Prada at Zara, bogus Balenciaga, and forged Fendi's on a street table at 14th and 5th. Do you feel there's any risk of alienating the mass consumer when you potentially bring in this legislation that would make your designs available only to the elite few?" And I'll quote one more line from Lynn, which is, "I believe copies provide a sartorial gateway drug, if you will, to young girls with no money, that the expensive stuff is expensive stuff is frequently just as derivative as the blatant copies." The idea being that you're hooking a customer that someday later will be able to afford your clothes and buy them. Is there any danger of disenfranchising fashion from the masses?
I don't perceive that risk. I think she's kind of mixing a whole bunch of things in there.
Clearly.
I mean, I go from M&Ms to Godiva as well. I mean, there's nothing wrong with that. But excuse me. But people will have fashion. They'll have trends. I mean, we don't set out to make trends. I'm not interested in trends, frankly. But they become that, and that's a way of influencing things. If early on we have a terrific bias cut trumpet dress, when that follows a grunge period, and all of a sudden girls are starting to wear dresses again, pretty terrific. But they shouldn't be copying line for line our dress. It's that simple, and I don't think people should get so upset by the intent or the if this bill gets passed and is effective, what it'll do. It just puts a very small group of people out of business, or makes them adjust their business so that it's not infringing on something that we've created.
It is a growing group of people, though, we should point out. Beyond Forever 21, there are other retailers starting up now with the same kind of concept. You've recently seen Old Navy change its business plan to incorporate more trendy fashion.
But trendy is okay. I mean, that's not what it's about.
The author of the quote that you just wrote, it frankly is rubbish.
But that's how a lot of young people feel.
No. But it's just rubbish. It's the justification. When I go in the courtroom and we talk about a trademark, and we talk about, which is easy for people to understand, and you talk about a fake item, like a fake, and that's what she was talking about. She just wasn't talking about knockoff. She was talking about fakes. And I once had somebody ask me, some reporter said to me, well, isn't this just a big company, knocking off little people? And I said, what's a big company? The answer is that it's a lot of little people. And it's people that are in shops, just like the ones selling the fakes, that are giving store space to the real stuff. It's the cooperative advertising that goes on. It's the manufacturing base that builds. It's the name that somebody may build and then license on extension, on brand extension. It's all of those things. And in my view, when you sell a fake, it's no different. It's absolutely no different than walking into a bodega with a gun in your hand and telling the guy to open up the cash register and give him the money. It's no different. It's theft. It's outright theft. So anybody that says to me that they justify this because it enables some person who doesn't have the means to buy the fake, or the one that looks so close that they'll be assumed to be wearing it, like a Posner item or like a DVF item that's in Forever 21, that's just rubbish. We used to hear that years ago, that, well, the guy that was working at McDonald's can't afford the real Reebok, so he ought to go out and buy the fake ones. And he'll tell you, most of those kids that I know, and we do enough jury research that I'm on pretty safe ground here, will tell you that if they bought a fake, they'd be offended. This is a person who's just writing with academia in her mind or something, but has no sense of what's going on out there. The single people that are the most brand conscious people in the United States right now are exactly the minority people that she's talking about. There's nobody more brand conscious, and there's nobody less fooled. That's just nonsense.
Well, I don't think people are being fooled by it. I think they're actually looking for those clothes in those stores.
Oh, everybody has a bit of larceny, to be sure. That if they didn't, you wouldn't sell the $10 Rolex. Mm-hmm. You wouldn't send, but it is that. It's not somebody who wants to look like they're wearing a real one. Mm-hmm. They know it's a fake. Everybody looking at it knows it's a fake. But you can't justify the theft of ideas and the theft of creativity by saying I should be entitled to steal it because I can't afford it. And that's what she's saying.
Okay. Let me ask you both, what do you think the chances of this bill passing are?
Zac and I went down to Washington, I guess it was a year and a half ago, and met with aides to various congressmen and senators, and I felt that it was an education process that we brought, and I'm sorry I didn't bring it here tonight, I should have, but a dress that we had done that one of the people we've mentioned today copied line for line. This is something I think will take some time. There's bipartisan support. So I think there's a decent chance. I think, right now there are discussions with different apparel groups and manufacturing groups to try and find, maybe fine-tune some of the language and make it, palatable to everybody. But I think it's something that really deserves passage.
I think that I can add a little bit to what Susan was saying. As I said, having gone through the legislative process and continually so, is because we enlist the aid of government in our anti-counterfeit efforts around the world. One of the things that you get your eyes open to really fast is all the different constituencies that are at play. Manufacturers, shippers, importers, large retail associations that are very powerful. This is an effort by a lot of relatively small people to band together. Yeah, it's being led by a Diane von Furstenberg, and she's got a huge brand behind her, but most of the people in that organization are much smaller in terms of their overall business numbers. And it is an effort on their part to counter what is an enormously powerful lobby, which is the retail lobby. And I think at the end of the day, because of the need to protect industry and developers of creative items of this kind, and also because much of the world, the United States is something of a pariah. They were late signing the overall Berne Convention, and most of the world had signed. The Berne Convention is a worldwide treaty where most countries recognize and undertake the obligation to enforce copyrights of foreign nationals if the foreign country will enforce our copyrights. And you're basically, it's an effort to harmonize the enforcement around the world. The United States signed the Berne Convention and does not, and violates it by not enforcing the rights that are granted to designers in England, the EU, in France, in Germany, what have you. There's an absolute per se violation. Now, that's never gone as high as some worldwide crisis at the WTO or something, but there's no question it's incredibly hypocritical. So I think that there's domestic pressure and there's also worldwide pressure. We're always yelling about how China doesn't protect IP, and we don't protect our own, nor do we protect the foreign creators, the non-United States creators that we're obligated to protect as a matter of treaty. But when that will happen, not before the election, that's for sure. Nobody's going to invest political capital in this before that election gets held.
And do you tell me a little bit about the power of the retail lobby? Because I think that's an issue that's not really understood by a lot of people. You've got a powerful lobbyist on your side, Liz Robbins.
Well, politics in the United States equates to dollars and cents. Politics, equates to media. Politics equates to the purchase of media, the ability to pay for media. And you've got to go out and they say that the day somebody gets elected, the day after, he starts raising money for the next election. And there are enormous forces at play. I'm not saying it's Walmart happens to be a client of our office, not in New York, but elsewhere. But if you're a senator from Arkansas, for example, on Walmart's home turf, you're going to be very responsive to a company that's that powerful. You may be equally responsive to if you're a senator or a congressman that that either through a PAC or some other giving mechanism, you've received significant support from an organized group such as retailers. And retailers have a very strong lobby. They put a lot of people in the field. They see a lot of people. They make their case. I'm not talking about, anything under the table and that sort of thing. If you have a guy who sits in front of you and is very persuasive and he's there all the time, you're going to start to listen to him. And the design group, the resources are different. They're just very different. So I think that's what you're talking about here.
I'm curious, why would the major retailers have an issue with this? I mean, that's not who we're talking about here. They just don't want to be under any obligation to worry about what goes on their shelves and racks. I mean, it's just an imposition for them to have to think about it.
It's more of an imposition. They see it as a potential liability. A very clear liability. One of the things that are being that you noted in your comment earlier was that
The law is still in evolutionary terms. And one of the things they're grappling with is, how do you define certain things? How do you define couture? What do you include when you say garments? And, does garments include, as it does now, the definition sunglasses? In the bill, it includes sunglasses. I'm not sure I would do that if I were writing that bill. I'm not sure that if I were in the retail side of things, a bill like this would scare the heck out of me. Because I don't know what my buyers go out in the field. They sit down with the factory. The guy says, "This is what's selling great," and I say, "Fine, bring in." And when you're talking about a single store that has 5, 6, 7,000 retail outlets, they put 10 garments, just 10 in every store. They have significant liability if it turns out later on that these are protected goods. So if I were them, I wouldn't want to see anything like this passed.
Good. I think at this point we'd like to open up the panel to discussion and questions from the audience.
I see a hand. Can't see something.
Hi. So let's say that this bill gets made into law. I'm just curious what happens with enforcement then. Where does this leave the designers in terms of being able to enforce their new copyrights? And doesn't this sort of, leave you in the same position as people like Herman Miller, for instance, who are always going after knockoffs of their own stuff, and it's very expensive?
Well, the sad truth is that only, designers who have huge businesses can afford to enforce these rights in any case. And that's why my interest in it is what I call the interiorum effect, the fear factor that will change the way people act. We are, a successful fashion design company, but have no kind of resource to have, an in-house staff to go, litigate and bring suits against, people who are infringing on us. It's hard enough even to have enough resources to file copyrights worldwide in the categories that we're in. I mean, these are just realities of existence. So, I don't think that we're going to be plaintiffs for a long time, frankly, even if the bill passes.
There is, again, supplementing what Susan had to say, a couple of things. You can't legislate morality, and you can't legislate behavior. Most people have learned that, the Voting Rights Act, the Civil Rights Act, a number of other things. But it gives you a place to start. If you're a small designer, and a couple of big designers do go out and implement this thing and bring people to task under this law, it will begin to change retail behavior. It has to, because from a retail standpoint, you're evaluating a risk versus reward. There's always a risk versus reward equation. When you're a store in today's world that lives and dies with knockoffs, for every one that you do, for every 10 that you do, that you get away with, maybe one sues you. 99% of those settle because of the cost of litigation. They settle. So you pay something, but that becomes then a cost of doing business. There's very little deterrent effect in terms of behavioral characteristics of those kinds of retailers. They're way ahead on the curve right now. So while it may be that, it certainly is the United States, that smaller businesses that don't have the deep pockets can't afford necessarily to litigate. And that's not always true, by the way. There are contingency situations that some people do. And the law, for example, in copyright provides that the loser does pay for the winner's counsel fees. It's the only law in the United States which does that. That was in an effort to address at least part of that recognized imbalance. So, but coming back to the point is, if the big guys go out and start hammering at some of these businesses, it will force them to evaluate, regardless of whether it's the big person or the small one. If they start changing, they'll change, I think, without real distinction between big and small. At least that's the hope.
And what about in the case of the boat holes? Did that have any impact? That was another industry that managed to get copyright protection kind of randomly. Did people stop copying boat holes?
Boat holes?
Boat holes.
I thought you were bolt holes.
It's hard for me not to sound too much like a lawyer here. That particular kind of law is known as sui generis. And sui generis, I'm sorry, and it's also generous. But it's a carve out from what otherwise would be the law, and the recognition was that hull design, regardless of the functional aspect of cutting through the water, floating the boat, and adding speed and economy, was in fact an aesthetic sales point. And a boat lobby managed to get that carve-out passed.
A hell of a lobby.
Yeah, they did a very good job, because there were some cases, and it happens that at that time most boat makers were, in Florida. There were influential senators in Florida. They were of the same political persuasion, and they got the carve-out passed. But this law that we're talking about now is much the same. It is the sui generis. It is very much a carve-out, a recognition that most copyright law will remain unchanged. The art versus functionality arguments will remain unchanged, except in this particular area. And there's a specific need to carve that out, because, yes, boat hull design sold boats.
And did people stop copying? Did it?
In large measure, yeah. In large measure, there were some major cases that were brought, and I imagine these days. But when you're talking about the very, very unique boats that brought that litigation, which was the Cigarette and the Barracuda type boats, these very high speed boats, there are very few boats now that copy those hull designs any longer. They move them away very specifically from those copies. And you got to remember something: you don't copy that which doesn't sell. So bad guys are not in the habit of copying, just to copy. They ain't trying to figure out what's going to sell. So if the big guys are selling and they move them off the big guys, the likelihood is they're going to stop copying.
I have a couple of comments. As a designer for 30-something years, my very first line that I ever did as a shoe designer, I was so excited. I was making $150 a week, and Bloomingdale's came in en masse, and they said, "Oh, we love this, so much." And they took all the shoes, and I never heard back from them. And 3 months later, all of the shoes, of course, were in Bloomingdale. So another part of the department store thing is their private label thing, which is huge. I mean, to a designer, like they're bad thieves. And the other thing I wanted to say is that I once did a shoe, which only because I found a lawyer they were just starting out and would take my case on contingency, I was able to get a preliminary injunction for the company who had knocked me off. And with that support could go to then a big, huge company like Stride Right and have the biggest SKU of one shoe ever, which is like the only successful in design I've ever had. And I teach at FIT, and I'm telling you, it's really hard to tell these students about, because we are so different from Europe. And, who's the chairman of LVMH? He's always saying, he's always saying that, it's terrible for American designers because we do not protect them. We do not nurture them. We do not encourage them. And we can go back to history. I mean, why is someone like, I don't know, if Herbert Levine shoes, Beth Levine, not as famous as someone like Manolo Blahnik, who his whole line is, one of her shoes that she did 50 years ago, Well,
what about the gentleman that's now doing, what is it, the Red Sole?
Louboutin, exactly.
Anyway. But there's in response to that, I can tell you a little story. Years ago when I was representing Reebok, they built their business on a little white shoe called the Freestyle shoe. And it was developed, and they actually created a new product category, which is every designer's hope and dream, as opposed to just making a better running shoe or a better, right? They created the category of an indoor gymnastic shoe. It had never been used before. Everybody simply used whatever sneaker they had, and they went to the gym with it, they played basketball with it, they ran outside with it. And these folks adopted essentially technology from an outdoor shoe to an indoor shoe, and said, because the fitness phase was just coming on. And I remember that at that time, they had their name in a little window with the British flag, and it said Reebok. And they also had a stripe on the side of the shoe. And the conventional wisdom at the time was that a stripe was not a trademark. Now, nobody would believe that these days because of the Nike swoosh, amongst other things. but that was conventional wisdom. And we went after a company called Dollar General, which is a publicly traded corporation. It has some 3,000 shops around the country. Most of them are in very small towns of America. They are linked by computer. They have a single employee, and everything is price point. Everything is price point driven. And when we went and we found a shoe that they were selling that was an exact copy for $5. Now, what it was a blow molded, it was an injection molded shoe. It wasn't leather, it didn't have rubber. It looked like it had all the pieces, but it actually was one piece. And in questioning these people, I said, how did you come to buy this shoe? And they said the factory came over, the salesman came in, he spread a bunch of shoes out, and he said, these are the ones that are selling. And the guy said, can you make that for less than $5? And that was it. That was the sum total of the discussion. And 3,000 stores had it about, 90 days later. Needless to say, my client was apoplectic at the time. And we ultimately resolved this by getting those shoes removed. But there's no question that the rights are only as good as the enforcement of them. So you have to have at least some people that will carry forward the culture, whether it's contingency lawyers or those who are obscenely expensive like myself, or somewhere in between, right? But we all make up the effort to have that happen.
We have time for one last question. Every time, two last. Hi. So my question's actually kind of coming from the other side. So if you're not someone who's deliberately trying to do something wrong, when you're someone who's trying to walk the line and be in the up and up, how do you keep abreast of what's out there that's copyright? For me, sometimes I find that just incredibly overwhelming, that fear of can you actually infringe on someone else's copyrights without even trying, And the other thing is how do you navigate the line between being inspired by something and infringing on someone else's rights? So is there really some rule of changing 7 things? I don't know.
I've never heard of that.
That's brand new. If you find that, let me know, though. I'd like that.
One point that's come up in the discussions between the Council of Fashion Designers of America and the American Apparel and Footwear Association, which is a trade group representing the mainstream manufacturers, are how some of the questions you just asked would be addressed. One thing that they've introduced now into the bill is a defense that is permissible if you can, as a designer, can prove that you coincidentally came up with a similar design. That's a legitimate defense that would protect you if someone was to pursue copyright infringement against you. But you'd have to be able to show that how you came up with the idea that you did. If you did have ignorance to someone else, if you could prove that you were not aware of someone else's design, you would have a strong ground to stand upon. As for the question of researching what's been copyrighted, this is a question that a lot of designers are asking themselves as well, because presumably they need to start hiring people that would specifically focus on watching what else is out there, pursuing litigation if necessary, filling out the forms that have to be filled out to register each design, which also require a description, as I understand it, of what is unique about that garment.
There's the now and the maybe tomorrow. The now answer to your question is, if it's not printed in a fabric that looks pretty unique, it's probably not subject to copyright. So that's pretty easy. The bigger question is, how, if the law comes to pass, then what does a young designer do? There are a couple of things that answer that. One is, now you don't have to register anything to get copyright protection. It used to be you did. But now the United States did sign the Berne Convention, which means copyright attaches at the moment of creation. You don't have to register copyright you have to register copyright to have damages and to get certain court-ordered relief, and you can quick do that if you find people, disturbing you. The new law, that the carve-out that we're talking about, requires registration and notice. You have to have notice. That's the point. So the garment itself will carry a notice on it, a hang tag, a fabric label, something will tell you there's a copyright here. You have to have notice. And the only way you can have notice under this act is if you register. So there's an imposition on the part of the designer. I mean, what's very interesting, apropos, the EU design right law, which is an all-encompassing design right, provided there's originality, will attach automatically from the date of first introduction for a period of 3 years without doing anything. You can go to court tomorrow to protect the design in all of the EU countries. The issue of originality, however, when the courts get it, is read very, very narrowly. Very narrowly. If it's merely ornamental, it better be really good, or they won't give you the coverage. However, if you record your right in the EU, you get 5 years of coverage and a presumption in your favor that you have the rights. Less than 1,400 designs have been recorded since the implementation of that law. Most designers have chosen not to use the law because they just don't feel like it's necessary, and they'll live with the 3-year issue if they in fact get covered. I suspect a lot of that may be true here too. You have to record under the new provision, and it's likely that many will not.
I was hoping to get your, I wanted to just tell you a quick situation and see if you had any input on it. My problem, I design materials and not prints, not weave structures. I went to art school, got a master's in decorative art history, and then became a materials scientist. And I work in companies. They'll bring me in and I'll make their plastics better, or their linoleum better, or their paper better. And my problem isn't being knocked, and I am largely paid on royalty. My problem isn't being knocked off by other companies, it's working with engineers. The engineers will come in and say, oh, well, now we're going to play designer too. And so it's in-house. I'm being knocked off, not outside. So if you have any advice for that, I'd love to hear it.
Look, I'm a little perplexed by it in the sense, how do they knock you off internally?
That they'll take something I do and they'll change a material. So they'll switch out a material, they'll change a load, they'll tweak the chemistry
of royalties.
Yeah, because even though when you look, the gestalt of the material is still the same. It's taking a commodity and making it a luxury product, but it's that the U.S. seems to protect a lot of engineering and technology and not design.
Well, there's a really fundamental distinction here, though. The U.S. If you go back a little bit. There's been a question which is now more or less resolved. Who owned it when you went to work for that company as an outside person? And a lot of times there was litigation between the creator who came in and the company. The company says, I paid for it. The creator says, I created it. So there was an evolution, and the company would then go out and try to stop knockoffs, and they would say, well, you don't own it because you didn't create it. So there became a doctrine called the work for hire doctrine, where there was a recognition that, assuming that the company had its paperwork in order, that it had paid for this, that it then would in fact own the copyright to that. It seems to me in your case that you need to get a better contract between you and the people that you're working with. If you want to have your rights created, you have to say, well, I want to own those rights, and you can't monkey with those rights unless I tell you you can. What they're going to say is, we're paying you, we can do whatever the heck we want to do with it, including change it. That's a matter of contract, not a matter of law.
My question is, how visual is the court?
Well, there's a very famous statue in front of the Supreme Court, and I think she's like this. And there's another saying that especially in the United States, and I've got a client recently, an Israeli-born woman who has issues, and I've tried to explain to her that in the United States there's a long way between law and justice, and they are not necessarily the same thing. There may be lots of things that should happen by reason of justice, but law is what happens in the four walls of a courtroom.
I mean, is the court in most cases an actual jury?
It can be either way. You can have a jury trial, or the judge can act as both the finder of fact and the finder on law. It's really a toss-up based on the parties. There's a constitutional right to at least the semblance of a jury trial. Jury trials, however, become unbelievably expensive. And so many people opt for a judge to apply the law in both the factual context and the legal context.
In your experience, how many things ever really get to court as opposed to settling?
Very few. Intellectual property cases generally, well, there are two reasons they resolve quickly. As the shoe design woman that had the good experience spoke up, if you get to court on a preliminary injunction, it's usually game over, because the preliminary injunction prevents the further production of the goods. If your trial is a year down the road, that preliminary injunction is going to prevent that production for that year. And if it's seasonally oriented product, game over. So usually if you get that far, which happens pretty quickly, that happens fast, case will then turn into a money case, and those usually will resolve. So the vast bulk, over 80% of the cases that are brought, never go to trial. When they go to trial, when it becomes a bet the company case. That's really when trials in the United States become really justified. We had, for years, represented Converse that had the famous star on the side of it. And it went to trial on a case against a company called Starter that wanted to use a star and integrate it with a Design S. And at that point, this was 15 years ago or so, Converse had 80 years of use of that star. And they felt that if they didn't fight, that something that was absolutely the lifeblood of that company would be lost. And if they lost that one, they'd lose them all. So that was a very bright line for them. But those are the kinds of matters that really go the whole way. Otherwise, no.
And where they had the resources to take it the whole way.
Yes. And
who won that case?
We won it.
We
had a full jury case, and they not only prevented Starter from using the star with the S design, but they even the jury felt so strongly about it that they also prevented Starter from using it even with the word starter, which Starter had argued clearly would distinguish its goods, and they said nope. And the jurors well understood it. They well understood it.
Well, thank you. I think the audience probably understands the issues a little better tonight, thanks to you too.
Thank you.